Oh.
May it please your Lordship. Lordship, I beg to make a mention of item number 6, your Lordship. Lordship, the learned TSGI, Dr. N. Musica, is not keeping well, your Lordship. May this matter be listed after 2 weeks, your Lordship.
Number 6.
Yes, your Lordship.
Objection, Lordship. Prayer for adjournment is made for on behalf of the respondent, Union of India, on the ground that the learned DSGI is indisposed on grounds of personal difficulties. The same not being objected to by the petitioner, prayer is allowed. This is matter up to 2 weeks.
2 weeks, yes, Lordship.
2 weeks.
Right, your Lordship. Lordship, similar prayer for item number 2, your Lordship. In CRP number 21 of 2016, your Lordship. May this matter be listed after 2 weeks, your Lordship.
2016 matter, my lord, and your lordship has heard it on several occasions.
Your Lordship, I'm for CRP number 28 of 2016. Your Lordship, even Mr. Casey got him. He's on sanction leave.
Lordship, I'd pray that a fixed date may be for this matter.
Mr. Dewa, it's pointless to go through that exercise because even if we give a fixed date,
But let it be
if
recorded, my
there
lord,
is
that
any contingency,
yes, it will be recorded. But I have strong objections to the
should
exam.
be. This court has also,
Yes.
time and again observed that it is a long pending matter, should be disposed of. And I believe the respondent has been heard in this matter.
Yes, I have also made my submissions, my lord, in respect of the maintainability.
Prayer is made on behalf of the petitioner, Kanihaka 28 Mokane, on the ground that the learned senior counsel who is conducting the matter being indisposed on account of personal difficulties. Mr. T.T. Dingdo, learned senior counsel appearing for the respondent, has raised strong objection to the prayer made on the ground that the matter is a long pending one and that time and again the matter has been heard in bits and pieces. The court on several occasions have also urged upon the parties to ensure that this matter is taken up in right earnest. However, due to perhaps unavoidable circumstances, matter could not be taken up. On this occasion too, since prayer on personal difficulty has been raised, the court would accede to the prayer made and accordingly the adjournment sought for is allowed. It is, however, again impress upon the parties that the matter should be taken up on the next date fix. How long?
2 weeks, Your Lordship.
As prayed for, this is matter to 2 weeks.
Similarly.
Took away
Similarly,
21
21.
took away 21 I took since the learned conducting counsel for the petitioner is on sanction leave, reportedly on sanction leave.
Your Lordship, just one more indulgence, Your Lordship. Your Lordship, preferably the matter may come up before the 8th, Your Lordship, because on the 8th, Your Lordship, Mr. Casey Gautama has some matters in Guwahati, that's why.
Doesn't matter. You see, the once
2 weeks,
2 weeks means 2
seventh,
weeks. Yeah,
second,
it would
second,
depend
third.
on the how the vote is is made up. It'll come up in due time.
Right.
We would, of course, we would avoid the 8th. Patrick.
Much obliged.
Much obliged, Your Lordship.
Please, Your Lordship. Lordship, I beg to make a mention on item number 9. Lordship, I'm praying for 2 weeks' time, Your Lordship. 9, sir.
I think, Mr. Khan, there is that, if I'm not mistaken, I could be wrong, there is that, query by the court as far as the, let's put it this way, the nomenclature of the case is concerned. this has come up against an appeal, isn't it?
Lordship, yes.
Appeal before the District Council Court.
Your Lordship.
Or what is this?
Pokso, Your Lordship.
Oh, it's POXO. Oh, that
Against conviction,
against conviction.
Yes.
But why would it, come by way of a revision?
Revision.
Instead of
Lordship
an
will put the
appeal?
query, yes.
Yes, I think that was the. Just try to find out.
Lordship will try to answer that.
Because as I may be wrong, but the understanding is that if it comes as a revision, the prayer of or rather the ambit is very limited.
Absolutely. 397 is very limited.
397?
Absolutely.
Only on
Parameteria with all the provisions.
only on issue of jurisdiction.
Jurisdiction and glaring illegality of law.
And if it is an appeal, then the court
You go into the merits.
goes to the merit, reappreciate evidence,
Absolutely.
which in a revision I doubt. But the fact of the matter is, it is against a conviction,
Against the conviction.
wherein the trial court has passed the judgment or impugned judgment rather on the basis of the
Merit.
merits of the
Merit.
case,
Appreciating the evidence in
appreciating the
detail.
evidence and all those things.
Lordship is very correct. But if this court hears as revision, so that question has to be formulated.
Yes.
What is the limited scope and way? So whether the court will under the umbrella of revision allow the petitioner counsel to argue at length. Those are issues. Lordship, let the senior counsel be. Mr. Paul is not here.
He was, yes, of course. The last time around, he said he'll examine that aspect of the matter. But of course, it's incumbent upon all.
Absolutely, Lordship. Lordship will assess the court. Absolutely, definitely. Then he'll have to restrain himself the illegality part only on that, and it'll be easy for us to reply on that.
And that would not perhaps do justice to the cause of the convict concern.
But Lordship is correct. It's a larger issue. Lordship is absolutely correct.
Please,
So maybe in course of hearing, maybe he'll review his decision to and crave the leave of the court to convert into appeal. That obviously he has always an option.
the power of the court is there.
I also was worried, Lordship, why revision against that conviction? Why what does he wants to restrain his area of argument, which is open-ended in appeal, wants to close it to an issue of law? Why would anybody do it?
If I am not mistaken, most of these cases, even under POXO, where sentence was below 7 years, and for which the single bench could take up the appeal, it's an appeal that has been used to be filed.
Absolutely. Only thing the single bench would take up, because below 7 years, above 7 years, division bench.
I don't know why in this case. You examine
But Lordship, on a lighter note, your Lordship's decision, though it was not considered by the Law Commission, 283 Law Commission report has finally agreed that in case of romantic relationship it is submitted his report on 27th. In fact, like Meghalaya High Court was the first High Court. I had argued the case before your Lordship. Lordship said, what would the purpose serve if they are married?
what was the report made?
And the report says, your Lordship, it has not reduced the age, but they have dealt with the issue of 16 to 18. In matters of 16 to 18, the court, only in the sentencing part, it has said it can pass any order below 10 years. So that would mean 6 months, maybe 1 year, maybe 1 2 years. So that's a major development that happened on 27th October. Unfortunately, your Lordship, 2 judgments from Karnataka and Kerala High Court that were referred. I wish our High Court's order should have been referred.
Makes no difference.
But then we have the footprints.
Issues.
Meghalaya High Court was the first High Court to deal with the issue.
We'll see how this Supreme Court deals with it.
Whether the government now translates it into a law.
And that is not for us to say.
So I just wanted to share this, Lordship, that Meghalaya High Court was the pioneer in at least in addressing that issues of romantic relationship part.
I have said time and again, it is not that this court has pioneered the whole issue.
But at least an issue was addressed.
I'm just following suit.
Because I remember, Lordship, I had argued the case and then we were a bit disappointed that within the 4 parameters, but finally Law Commission has addressed the issue.
Okay. If you want to pat yourself on the back, fine.
Lordship, yes. No, but we wanted to see Meghalaya High Court's footprint in that. In some other way, Lordship, maybe. Oblige, Lordship.
Huh? On pre-meet with the parties, this is matter of the 3 weeks.
I beg to make a mention for item 3, Lordship. 3 and 4, Lordship.
Item number
3 and 4, sir.
3 and 4.
This is also 2019 matter.
Repeated matter may fix after Pujai Lordship.
Yes, Mr. Paul Hitus.
Mr. Paul is actually having some difficulties, Lordship.
On pre-made by the petitioner. List this matter up to 2 weeks.
Highly obliged, Lordship.
May it please your Lordship.
What else?
I beg to mention item number 7. On behalf of Miss R. Colney, she's indisposed, Lordship.
Yes. Yes, what is your submission? You are for the petitioner.
Yes, Your Lordship.
Any objection?
No objections, Your Lordship.
Prayer is made for adjournment on this matter on the ground of, on the ground that the Leonard G.A. Ms. Arkulni is indisposed. The same not be objected to by the petitioner. Pray allowed. This is matter to 2 weeks.
Highly obliged.
May I please your Lordship? Your Lordship, I beg to mention item number 8.
Yes. What is this matter about?
It was a very small issue involved. They had waived their right for objection for gradation list on a basis of oral statement.
Okay.
And the Lordship will recollect, our only state stand is that once you have waived the right, can you again claim entitlement? And they said they have waived the right not by written thing but oral.
It's issue of gradation.
Gradation is Lordship.
How can you waive your right?
Your Lordship, they had an option to question the gradation list.
Option is given.
The option was given, they chose not to file any objection.
Okay.
And their submission before the court is this, they had orally objected. And for us, for the state's contention is that, Your Lordship, there is no provision for oral objection. We would not know what was the oral objection. And that is the only stand the state takes, that they were given an opportunity, they chose not to object.
To have the, you see, so, okay. So a form is given
Lordship, yes.
and you have to take
Lordship, yes.
whether you object or not.
And the Your Lordship, the provisional gradation list is published normally with a writer that anybody has got any objection to it, kindly file it within a reasonable time. So that reasonable time was 30 days.
If you are to object, it would be objection only vis-a-vis the other
Lordship, yes.
colleagues, so to say.
Other colleagues. And basically,
But
supposing
then,
there is
as far as your standing is concerned, where is the objection for you not to be upgraded or put in the...
Absolutely. On merit, we stand our ground that everything is correct. Their only contention was whether, when they got an opportunity to object, did they choose to object by a written submission and giving in the details why these things are not correct. They did not find.
Also, they were aggrieved, whether he or she. He is aggrieved by the final gradation list
Lordship, yes.
published.
And then the contention that he takes before the court is that they may not have filed a written objection, but orally they had said somewhere. And we said that oral objection has got no sustainability in law.
We'll examine the matter.
That is the only issue involved.
On pre-made by petitioner, this is matter up to 2 weeks.
Supplementary cost list, item number 1.
May I please, Your Lordship? Lordship, the petitioner is the accused in the case who was arrested on 12/2/2023. Your Lordship, this petitioner was in fact kidnapped by the 6 accused persons. Now they have already been enlarged on bail, this 4 accused person. I am still in jail, Your Lordship. And Your Lordship, bail was filed on behalf of the petitioner before the learned trial court, which was rejected. And Your Lordship, while rejecting the bail, the learned trial court recorded the observation that the trial would be expedited within 3 months. Being aggrieved, I approached this honorable court. However, this honorable court was also pleased to reject my bail on 31st in month of July. This honorable. My lord, now sufficient material has come because 4 witnesses already been examined, and these 4 witnesses, Your Lordship, my innocence is already established. However, now my difficulty is that, Your Lordship, I may approach the trial court, but trial court is not inclined to entertain the bail application because this honorable court has rejected. So
Why that is there a bar?
no bar, but Your Lordship, the trial court. That's why I have filed, Your Lordship. If Your Lordship, I may withdraw this petition if Your Lordship may kindly allow grant liberty to. There is no bar, but the trial court, Your Lordship, since it was rejected by the Honorable High Court.
The trial court would be in a better position to
Yes, Your
understand
Lordship. That's
your
why.
case.
Yes, Your Lordship.
It's taken up the matter.
Yes, Your Lordship.
So the matter has gone for proceeded for evidence.
4 witnesses already examined out of 10, Your Lordship, and sufficient material already come. So, because this honorable court was pleased to reject my bail, then the trial court is reluctant.
I'll make an observation that you are withdrawing this with liberty to file it before the
Learned trial court.
But Mr. S.A. Pandit, learned counsel for the petitioner, who has submitted that at this juncture, this petition will be allowed to be withdrawn with liberty to file a similar petition before the trial court. On pyramid, the said prayer not being objected to by Mr. H. Karawalang, learned additional senior GA, appearing for the state respondent, the same is allowed. Petition is dismissed as withdrawn with liberty sought for allowed.
Daily cost list item number 1.
Yes, madam, have you taken steps?
Yes, I have taken steps, sir.
And
Then, sir, please, the condonation of 300
no,
days may be
have you taken
allowed.
step? Have the the
Yes, I have given to
respondents
Sir
have,
Yogin. Then,
respondent have received notice?
yes, sir. They have signed also, sir. Signed also.
Have you filed an affidavit of service?
Yes.
Have you filed an affidavit of service? Or who's appearing for the respondent?
My lord, I'm praying for state. My
Or
lord,
for the state. So that is for respondent number 1. What about respondent 2 and 3?
They didn't come, sir.
No, have you taken
Yes,
step?
I have given, sir. Sub noticed.
Sub notice. Have you filed the affidavit of service?
Affidavit, I didn't file, sir.
Then you should. You're just showing in the court that they have signed. Do it properly.
Okay, sir. Done.
If they have received notice,
Okay.
then file an affidavit of service
Okay, sir.
so that it will be on record that they have acknowledged receipt.
Okay, sir.
my lord, as per the last order, we are to receive the correct copy of the petitions.
Or they have not. You have not given.
Given, sir.
You have given.
Yes, sir.
My apologies.
Already received. Already received. Yes.
Anyway, you check and confirm.
Already received.
You do that outside court, doesn't matter. That is between you. Learned Mr. Learned counsel for the petitioner has submitted that the notice issued upon the respondent 2 and 3 have been affected. However, it is prayed that an affidavit of service may be allowed to be filed in this regard. Mr. Learned GA has appeared on behalf of the respondent number 1. Would you like to respond to the application or?
My lord, actually, Mr. Andy Shulai is leading the proceedings.
Mr. Shulai was here.
He's having a matter in. My lord will reply for that.
Kununtuang, the last line. And has submitted that the state respondent may be allowed to respond to the application filed by the petitioner. Same as allowed. On premiere, let's this matter up to 2 weeks.
Copy. In fact, Lordship, we are supposed to get the corrected.
Yes,
Correct.
she said
Already received.
your colleague has submission has submitted that him response may be allowed to be filed. If you want to file and respond, do it. If not, we'll proceed. Thank you.
Item number 5.
Yes,
Your Lordship, this is a prayer seeking direction for release of their land compensation.
This is that matter, my lord.
That matter, there is another matter in the court number 4.
Yes, what was the
Then, my lord, it's regarding land acquisition, my lord.
yes.
Land acquired by, supposedly acquired by the BSF, my lord. Now the compensation could not be paid because there was a dispute between the petitioner and.
Yes, I think query was made by this court last time around,
Yes,
whether there
Your
was
Lordship.
any, petition under section 30 or so on and so forth.
Everything has been completed, Your Lordship. Land acquisition has been completed.
Yes, land acquisition completed.
Completed.
Only the award is not yet disbursed
Yes.
because there is apparently some dispute
Some
with
third
regard to
party is claiming
with regard to
ownership.
ownership.
But that also
that aspect of the matter has to be dealt with by the special court
yes.
under section 30.
But in this case, it is an Akung land, Your Lordship. So
It may be.
both the matter has been settled by the court of EM and also court of CM, and they have given in favor of the petitioner here, Your Lordship. So concurrently passed by the two courts have upheld the ownership of the petitioner here. So now in that another case, they have called for a record of the district council proceeding. So they have given 3 weeks. So it will be after Puja holiday.
So
That one.
So this case would be dependent on the outcome of that case.
Yes. In fact, Your Lordship, this has been settled in favor of the petitioner. Everything. Land acquisition has been acquired in favor of the petitioner. Document, original document, everything has supported the.
Those are issues of facts,
Yes.
or rather the merits of the case,
Yes.
which this court may not be required to go into at
Yes.
this stage.
Of course, Your Lord.
The only difficulty is, suppose, my lord, the state goes ahead and releases the fund, my lord. Now, subsequently, what happens if the other petitioner succeeds in that case, some way or the other, then it will become a problem. Otherwise, for us, disbursing the fund is not an issue. Once it is finally settled, we have no issue.
That is why, you see, again, at the outset, this court has made a query as to whether any proceeding under section 30 is there. Because you may say that the EM or the CEM or the district council court may have settled the issue or confirm your ownership, whatever. The fact remains that it is a land acquisition proceeding. It has to go in a proper procedure, of course. You are the one who makes the rules, so you should know better. So the procedure has to be followed. It has to go before a special court, and the special court will determine.
They have, according to record, they have determined, Your Lordship.
So now, what remains? If it is an appeal against such a order of the, then it may have been.
If I'm correctly remember, my lord, this case, the petitioner and the other party, my lord, they were involved in a title suit which was being conducted in the district council, my lord. So thereafter, I think several findings were there. Now, the thing is that ultimate outcome, what is the outcome? Once it is finally settled in favor of petitioners, we have no problem.
Yes, that's what Mr.
Your Lordship, the third party have come to this honorable court twice only, but they have not succeeded in 2016. So this is for them in that another case, it is the second round of litigation, third round of litigation already.
Fine, then we'll wait for the outcome of the other case.
Yes, Your Lordship.
Heard Mr. L.M. Sawa, learned counsel for the petitioner. Also heard Mr. P.P. Parsaji, learned GA, appearing for the state respondent. Appearing for the respondents 1 and 2 respectively. It is the submission of the parties of the learned counsels that there is a matter pending before another bench of this court relating to the same subject matter, wherein if the said case is disposed, the outcome thereof would have an impact and bearing on this case, for which the counsel has submitted that but how soon will we expect the
in that case, of course, I am not there.
Last time, Your Lordship, they have called for the record of the district council, but they have not come. So another 3 weeks has been fixed. Just
Let it come after 3 weeks or 4 weeks.
Then it will come after 4 weeks.
4 weeks.
Yes. Totoo event. Em top nung hapuli event to ka lagi. It's something that this matter may be put on hold for the time being. Accordingly, on prayer being made, this matter is adjourned. This the same after 4 weeks. 4 weeks.
Highly obliged, Your Lordship.
Sure.
I spoke to them. Yeah.